In the words of the former President Dr. Kalam, where do evils like corruption arise from? It comes from the never-ending greed. The fight for corruption-free ethical society will have to be fought against this very greed and replace it with what can I give attitude. Hello everyone and welcome to Byjus Exam Prep IAS and welcome to yet another session on knowledge series. In this video, we will be discussing about Lokpal. Now we will start our discussion with a brief background of the concept of ombudsman. We will then move on and understand the background of Lokpal and the Lokayukta Act 2013. We'll look into the provisions and towards the end, we'll discuss some issues and concerns, and finally, I'll take up some questions from you guys. So let's begin our discussion. First up, a brief background. This idea of ombudsman. Ombudsman is a term which basically means somebody monitoring government officials. So the institution of ombudsman first came into being in Sweden way back in 1713. This was when this system started. When the Chancellor of Justice was appointed by the king to act as an invigilator to look into the functioning of wartime government. From 1713, it became the duty of this ombudsman to primarily ensure that the correct conduct of royal officials was being put in place. Finally, the institution of ombudsman was firmly incorporated into the Swedish constitution from 1809 onwards. Now coming to the history of ombudsman in our country. The story of the passage of what you see as the Lokpal and Lokayukta Act has a long and arduous history. 8 attempts all failed, right from 1968, 1971, 1977, 1985, 1989, 1996, 1998 and 2001. 8 failed attempts. One of the main reasons behind this can be the perception amongst the MPs that this Lokayukta and Lokpal was just a tool which was meant to harass them. It was so sensitive in nature that it always found itself in the coal bags of both the legislative houses. Now, for the first time in 1963, in this year, the idea of an Indian ombudsman emerged through the halls of the parliament while discussing about the budgetary allocation for the law ministry. The term Lokpal, which literally means People's Protector, Lokpal, was coined by L.M. Singhvi. L.M. Singhvi was a Rajya Sabha member and a very respected and renowned jurist. The main aim behind establishing the institution was to control the practice of corruption which was eating the core of the government and its system. Then we had the first ARC, the Administrative Reforms Commission under the chairmanship of Morarji Desai and then Kengal Hamantayya. Then we had the National Commission to review the working of the Constitution. Mind you, first ARC was set up in 1966, the Administrative Reforms Commission. NCRWC of 2002. Even the second ARC that was set up in 2005. All these commissions kept on giving recommendations that there should be a Lokpal in place, a body which could keep a check on corrupt government officials. You know, people's indifference is the best breeding ground for corruption to grow. With some of the activities of corruption being exposed under the UPA government, with each passing day, the country finally had enough. then started a movement by the people, like a ray of hope for India, spearheaded by the former armed forces official Anna Hazare, which called for the enactment of a Jan Lokpal Bill, the movement which came to be known as India Against Corruption. Every day we had some kind of scam being unearthed, exposed, and people were really fed up. So we wanted a law. And again, after many failed negotiations, Bollywood celebrities coming to Delhi, entering the fray, things like Lathi charge in the Ram Leela Maidan, including a 4-day hunger strike, finally made the government relent. And it agreed on setting up a commission comprising of the government and some members of the civil society for drafting a bill. They came to a compromise and introduced what came to be known as the first ever draft bill. There were 2 bills introduced, and again there was some deliberation, discussion, and after much of this discussion, the government withdrew the 2 opposing bills and came up with the first Lokpal and Lokayukta Bill in 2011. Finally, with minor changes, minor modifications, we saw the passage of the Lokpal and Lokayukta Act in the year 2013. That became known as the Lokpal and Lokayukta Act 2013, which came into force from the 16th of January 2014. So, right from 1963, when the then Law Minister Ashok Kumar Sen proposed the concept of Lokpal, 8 failed attempts, and the 9th time we were successful in getting the Lokpal and Lokayukta Act passed. And finally, this country got an omniscient and omnipotent body to slay the demons of corruption. Now, the Lokpal is an institution for the union, and Lokayuktas are the institutions for states. So we have one Lokpal, and for every state we have Lokayukta. There are some UTs like Pondicherry, UTs like Jammu and Kashmir and Ladakh which do not have such a provision. Barring them, every other state has a provision of Lokayukta in place, and center has a provision of Lokpal. So what exactly is the purpose of this Lokpal? See, when it comes to the purpose is to inquire into allegations of corruption against certain public functionaries and for related matters. A complaint under Lokpal Act is with respect to allegations of corruption against any public servant who is covered. We'll see shortly which category of people are covered. So, allegations of corruption against those public servants, and it must pertain to an offence under the Prevention of Corruption Act 1988, which includes things like bribery, criminal misconduct, amassing of disproportionate assets, etc. So this is the purpose of Lokpal as well as the Lokayuktas. Now coming to the composition of the Lokpal, Lokpal comprises of a chairperson and maximum 8 other members. Now when it comes to the chairperson has to have a qualification of either being a former Chief Justice of India or a former Supreme Court judge, or any person who is an eminent person with impeccable integrity and outstanding ability, who has special knowledge and expertise of minimum 25 years in fields of vigilance, finance, public administration, anti-corruption policy, insurance, banking, law and management, etc. So either of these 3, a former Chief Justice of India, former Supreme Court judge, or somebody who is an eminent person. This is the criteria for the chairperson. Now, the law was passed in 2014, and for the first time in 2019, in the month of March 2019, we appointed a chairperson for the Lokpal, retired Supreme Court Judge Justice P.C. Ghosh, Pinaki Chandra Ghosh. Now, Justice P.C. Ghosh retired just last month, in the month of May, and now, as of now, currently the post of chairperson is lying vacant. One member of the Lokpal is working as an acting chairperson. So you see, one of the most important bodies, the government has not found the time to appoint a chairperson for the same. Anyway, moving on to other members. Now, when it comes to other members, there are two types of members under Lokpal. The first one is a judicial member. So you need to have at least 4 judicial members. Half of the members have to be judicial and the other half can be non-judicial. So you see here that the 2 judicial posts are vacant. We currently have Justice Abhilasha Kumari and Justice P.K. Mohanty, who is also the acting Lokpal, the chairperson of Lokpal as of now. And we have 4 other people, and the qualification to be a judicial member is that you have to be a former Supreme Court judge, or you could be a former Chief Justice of any High Court. And when it comes to a non-judicial member, the administrative members of sorts, there the qualification is the same, which we saw: somebody who is an eminent person, somebody with impeccable integrity and outstanding ability, and 25 years of experience in various fields. Beyond this, what is important is, as I said, half of the members should be judicial members, and minimum 50% reservation amongst the members with respect to scheduled castes, scheduled tribes, OBC, minorities, and here I mean to say the religious minorities, and women. So this is the current criteria of members and their qualification and eligibility. Now, how are the members appointed? The members, as you are aware, are appointed by the President of India, but on the recommendation of a selection committee. That selection committee consists of 5 people: the Prime Minister as the chairperson, the Speaker of Lok Sabha, the Leader of Opposition in Lok Sabha, the Chief Justice of India or the senior-most Supreme Court judge if the Chief Justice is not there, and 1 eminent jurist. Jurist is basically any person who is an expert in the field of law. Somebody who is a champion at legal theorizing is what is called a jurist. So these are the people from the selection committee whose task is to give recommendations, make suggestions, and finally make this recommendation to the President, who will go on and appoint the members of the Lokpal. With respect to term of office, the term of office is either 5 years or 70 years, whichever is earlier, and the salary and allowances and other conditions of service of the chairperson of Lokpal is equivalent to that of Chief Justice of India, and with respect to members, it is equivalent to the Supreme Court judge. I am sure you are aware that the salary of Chief Justice is 2.85 lakhs per mensem or per month, and the salary of Supreme Court judges is 2.5 lakh rupees per month. Now, coming to the removal process. So the members of Lokpal can be removed by the President if 100 MPs sign a petition, submit this to the President on grounds of misbehavior, whereas misbehavior is not defined, but if they feel that the member of Lokpal has been involved in some kind of misbehavior, they can file a petition and give it to the President. The President will ask the Supreme Court to conduct an inquiry, and based on the report of the inquiry, if the Supreme Court finds out that the allegation of misbehavior is true, the President removes the member, and if the allegation is false, then no step is taken. In fact, this kind of removal by the President on grounds of misbehavior after the inquiry of Supreme Court, not the reference of MPs and all, but just this part that the President asks the Supreme Court to conduct an inquiry, is a process which is used for removal of lot of categories of people. For example, the members of CIC, the members of UPSC, the members of NHRC, etc. While there is another process of removal which is done by the Parliament, following the Judges Inquiry Act. That is how the Supreme Court judges are removed. That is how the Chief Election Commissioner is removed. That is how the CAG is removed. That is how the High Court judges, the State Election Commissioners are removed. So that's different. Removal by the Parliament. This is removal by the President after Supreme Court's inquiry. This is how the members are removed. Now coming to jurisdiction. Lokpal has very wide jurisdiction. It covers every public servant and the central level. At the central level, right from the Prime Minister, all the cabinet ministers, all the ministers of state, independent charge, all the ministers of state, every union minister, we have the Group A officers, Group B officers, Group C officials, Group D officials, all the MPs, including the PSU staff, everybody is covered. Now, who is not covered? Armed forces, not covered. Coast guards, not covered. And yes, of course, judiciary is not covered. So, Lokpal cannot take up complaints against the armed forces, against the coast guards and the judiciary. Otherwise, all other public servants under the central government are covered under Lokpal. Similar kind of provision for the Lokayuktas. All state government employees, including the chief minister, the ministers in the state, the MLAs, MLCs, all of them are covered under Lokayukt. So this is the jurisdiction with respect to the Lokpal. Now, as far as the Lokpal is concerned, Lokpal functions in benches, just like Supreme Court. So every Lokpal bench will constitute of the members, of which half of them will have to be judicial members. And the bench should have a minimum strength of 2. So every complaint that you file in the Lokpal has to be heard by at least 2 member bench. It's just like in Supreme Court where we have a division bench consisting of 2 judges. Okay. Now, what is the process of filing complaints? So you will be surprised to know that the body was formed in 2014, the appointments were made in 2019, and finally how to follow or how to write complaints. The guidelines were issued in 2020. You see how efficient the governments have been in eradicating corruption, how quick they have been in appointing people and providing guidelines. It takes them 5 to 6 years to appoint people and provide guidelines to file complaints. Anyway, a complaint to the Lokpal can be sent by post or courier or by hand to the office of Lokpal located in Delhi, Vasant Kunj. You have the address, you can get the address from the website lokpal.gov.in. Beyond that, a complaint can also be sent to the email, that is complaint-2-lokpal@gov.in. Now, complaints sent by any other means are not acceptable, and complaint should be in English only. And yes, citizens and non-citizens, both of them can access the Lokpal and can file a complaint, but yes, you have to give your proof. So a foreigner can give a passport as proof, and for others, various proofs that you have, Aadhaar, PAN, etc., have to be submitted. Anonymous complaints are not entertained. And don't worry, the law says that the inquiry committee of the Lokpal will never take any step to know or verify the identity of the complainant. So it will by and large remain a secret. Now, one very interesting aspect of the complaint filing, which makes the process complicated uselessly, is that yes, there is a provision for online complaints, sending complaints via email, but every complaint that is filed through an email, a hard copy of the same has to be taken out in the form of printout and has to be submitted to the Lokpal of India within 15 days of sending the email. We really don't know why this provision is added. It completely takes away the entire idea of filing online complaints if you have to send a complaint via post or courier. Then every complaint should also be on a non-judicial stamp paper. In fact, this is nothing. If you go to some states, in various states in the Lokayukts, say UP or Gujarat, you have to submit 2,000 rupees to file a complaint. In Punjab, in Manipur, you have to submit 1,000 rupees in the form of demand draft to file a complaint. And then in some states like Himachal, you have to submit just 3 rupees to file a complaint. That's again a non-uniformity of provisions across the Lokayukts. Now, coming to the powers, the Lokpal obviously has the power of superintendence and control over CBI. So Lokpal will not investigate per se. It has CBI. It receives a complaint. If it finds merit in your complaint, allegation against a public servant, it will ask the CBI to conduct an inquiry and investigation. In fact, Lokpal can also authorize the CBI for search and seizure operations connected with the case. Beyond this, it's very interesting to know that if any case has been referred to CBI by the Lokpal, the investigating officer in such a case cannot be transferred without the approval of the Lokpal. Beyond this, the Lokpal also has powers for confiscation of assets as well as proceeds, receipts and benefits which arise or are procured by means of corruption. Lokpal can also recommend transfer or suspension of public servants connected with the allegation of corruption. So these are the powers that are there with the Lokpal. Now, what are the limitations? First things first, the big limitation is that Lokpal cannot take up complaints which are older than 7 years. That's the limitation number 1. Limitation number 2, judiciary is not covered, and so is the category of services, the armed forces along with the coast guards. They are not covered under Lokpal, and Lokpal cannot conduct an inquiry against itself. If you want to complain against the members of Lokpal, you will have to approach the members of parliament, and 100 MPs have to sign in writing the allegation, and only then will it be accepted by the president, who will ask the Supreme Court to conduct the inquiry. These are limitations with respect to the Lokpal. Now, the Prime Minister is also covered under Lokpal. How is a Prime Minister covered? Obviously, there can be no faith in the government if the highest officers are excused from scrutiny. So the Prime Minister is also covered, but there are slight differences, some minor modifications. If you complained against the Prime Minister and your allegation of corruption relates to 5 topics, that is international relations, external and internal security, public order, atomic energy and space, such complaints can't be filed. Lokpal does not have the authority to take up inquiries on allegations with respect to these 5 topics. They are all sensitive and strategic areas, so excluded from the purview of Lokpal. Beyond this, whenever any complaint is filed against or allegation of corruption is filed against the Prime Minister, the entire bench of Lokpal has to sit and look into the complaint and decide whether the inquiry should be allowed or not. So first things first, the entire bench of Lokpal, it will take up the matter, look into the matter, and of these people, at least 2/3 people are required to agree, and only then can an inquiry be initiated against the Prime Minister. This is the minimum requirement against the Prime Minister. Moving on, with respect to the Prime Minister, if all the inquiries that are being done against the Prime Minister are to be done on camera and not off camera, and the moment at any given point of time during the inquiry, if it is found that the allegation is not true, all records of inquiry, the inquiry is stopped firstly, and all records of inquiry are made confidential and are not up for public display. They are not open to public. They are confidential and the public cannot file an RTI to access these documents. The inquiry against the Prime Minister in case the allegation is found to be untrue. So this is the PM being covered under Lokpal. Now just to also mention certain smaller issues. The first issue is the complication in filing complaints. I mean, look at this situation that if you have to file an online complaint, then you have to also send an offline complaint. In a situation where Lokpal is already suffering from a lack of awareness problem, every year CVC receives close to 81 to 84,000 complaints. This is the number of complaints that the CVC receives against Group A officials. And look at the complaints received by Lokpal. In 2019, when the chairperson was finally appointed, Lokpal received 1,427 complaints, where the coverage of Lokpal is way wider than the CVC, the Central Vigilance Commission, which only covers Group A officials. Then, come 2020, when the guidelines were clarified, the complaints dropped down to just 110. And as per the latest data, till 2021, that is mid-2021 June, that's the latest data we have, the number of complaints that the Lokpal received were just 30. And mind you, 60 crore rupees has already been invested in setting up the entire system of Lokpal. Plus, Lokpal cannot take up suo motu complaints. Suo motu meaning on its own motion. There are some states wherein the Lokayukts can take up complaints on their own. We see judiciary. When judiciary reads an article, press report, or even if you send a letter, judiciary can take up the complaints on its own in the form of a PIL. But Lokpal is not allowed to take up complaints on its own. Somebody has to file a complaint. And there is also an issue between the Lokpal and the CVC with respect to jurisdiction of CBI. Both Lokpal and CVC, even though Lokpal is a superior body, because CVC also keeps Lokpal informed of all the investigations being carried on, and the Lokpal can also order the CVC into taking up complaints against Group B, C and D officials. Otherwise, CVC restricts itself only to complaints against Group A officials. Beyond this, now the big problem is both Lokpal and CVC depend overwhelmingly on CBI. And sadly, CBI itself is running short of staff. Plus, the highly politicized functioning of CBI, so much so that Supreme Court a few years back had to say that CBI is like a caged parrot, speaking its master's language. So these are some issues and concerns that affect the Lokpal. Now, just to end our discussion here, without strong watchdog institutions, impunity becomes the very foundation upon which systems of corruption are built. And to tell you, and if impunity is not demolished, all efforts that we take to bring an end to corruption are in vain. You know, laws will not serve the purpose. Lokpal or Lokayukts or such bodies would just be another bureaucratic tool. As the famous Roman historian said, more numerous the laws, more corrupt the state. And finally, and ultimately, corruption is eventually paid for by the poor. So that is all as far as the Lokpal is concerned. I'll take up some questions from you guys. So questions if you have any. First question, which organization has the highest power? Obviously, Lokpal has a higher power. Lokpal is the controlling authority. It orders, regulates these bodies like CBI. So it has higher powers. Lokpal is a statutory body, not a non-statutory body. Why? Because Lokpal was established under the Lokpal and Lokayukta Act 2013. Why are governments unwilling to create proper anti-corruption mechanisms? As I said, with respect to Lokpal, primarily, the fear amongst the minds of the politicians, the MPs, was that it could be used as a tool to harass them, and hence the unwillingness on their part. And the contribution towards making proper strong bodies has been very tardy, largely also because of bureaucrats who are afraid that these strong bodies could be used as a tool to scuttle their functioning, because people can file false allegations and complaints and can trap them. So before any body is set up, lot of precautions are taken to avoid false complaints, and that is why this process has been very slow, very tardy when it comes to having strong bodies which can curb corruption. So do you think the investigation agencies should be abolished and a robust and empowered Lokpal? See, Lokpal cannot be called an investigating body. So we need CBI, ED and all, because these are investigating bodies. These are the arms of bodies like CVC and Lokpal. Rather, if you look at CVC as well, so many recommendations of CVC given every year on various disciplinary actions to be taken are never taken by the government. We have seen so many cases every year that there are 70 cases, 70 complaints by CVC, let's say in a particular bank against senior officials, and the government takes action against 2 people. Complaints against 33 officials of a bank, government takes action against not a single person. Complaints against 263 people in one ministry, and government takes action only against 81 of them. So the recommendation of these bodies, since they are not binding, it is left to subjectivity of the concerned government. That's also a problem. Can Lokpal inquire into judges and other members of the judiciary? Obviously not. Lokpal cannot inquire into judges and judiciary. Why? Because judiciary is independent, and the removal of judiciary, the inquiry against judiciary is conducted by judiciary itself, and the removal takes place in the parliament by a special majority. In fact, so complicated and difficult is the process that we have never seen a single judge being removed, despite allegations and proved allegations against various judges. The complication in procedure is such that not a single judge has been removed. Also to ensure that they are independent and perform the activities with utmost safety and precaution. So that is all as far as this video on Lokpal is concerned. That's all for me for this video. Jai Hind.